Contact tracing is becoming an increasingly important step to reopen the U.S. safely and mitigate the spread of coronavirus. But some privacy concerns are arising over what and how much information government officials may have. CBSN legal contributor Keir Dougall joins us now with some insight on this. Keir, good to see you, my friend. So what should the general public know about their rights when it comes to state governments tracking them? Because we've seen this implemented in other countries to great success.
Good morning, Anne-Marie. Good morning, Vlad. That's a very big question. Right now, in this era of a pandemic, we're trying to do three things, and it's hard to do more than two of them simultaneously. We are trying to protect our health and our lives and our jobs as one thing. We are trying to protect our social ability to gather, and we're trying to protect our privacy as a third thing. And it's really hard to do all three at the same time. In ordinary times, outside of a pandemic, you have basically the entire Bill of Rights or multiple rights in the Bill of Rights protecting you from government surveillance, from the collection of information by the government. But in the time of a pandemic, there are, as you would expect, some exceptions, some different treatment. And over 100 years ago, the Supreme Court, in a case called Jacobson versus Massachusetts, that arose in a smallpox issue, the court basically said that the community has the right to protect itself. It's a matter of self-defense. And so if public health officials, experts, tell our elected officials that there are reasonable steps that should be taken that might otherwise invade your constitutional rights under the Bill of Rights, but that should be taken in order to protect our health, that's okay. Now, those steps have to be reasonable. They can't be pretextual. They can't be an effort to accomplish something that is beyond what is reasonable to address the health issue. But those are the basic rules of the road now in a pandemic.
Yeah, when I heard about the importance of contact tracing, I thought exactly what you thought. What you just mentioned is that, we have privacy concerns here. Our privacy is protected by law. We have pretty strong HIPAA laws, in particular protecting your personal health information. So what data is the federal government or any government privy to in order to protect the public health?
Right. So Anne-Marie, the short answer is that if it's reasonable, right, if our health officials have an evidence, science-based, reasonable need to gather information, the government is going to have a right to get it. The question becomes one more of practicalities and how do you get it? And so other countries have used different forms of contact tracing from old school, just have people run, go out and do the interviews, to using technology. Of course, the big concern with gathering all this information is, and privacy advocates are right to worry about this, is that it can be used to harass, it can be used to intimidate, it can chill people's political activity. It's of great concern that it be handled appropriately. It can end up in the wrong hands if there's a data breach. All of these things are of concern, but the government has generally, as long as it's reasonably tailored to the need, the ability to gather this information.
Keir, PricewaterhouseCoopers is using a contact tracing application for its employees at its Shanghai firm, the first location to reopen since the pandemic. As more businesses reopen and some enact these COVID-19 surveillance measures, can an employee refuse participation if they think the company is overstepping or if they feel their rights are being violated?
So that is another great question, and we move now into a different area. It's different when a government is seeking information and using its coercive powers to gather it, as opposed to information that's gathered in the private sector by a private sector employer, that relationship is generally voluntary. So it's different. Now, in the United States, the EEOC has issued guidelines about what information that an employer can gather in the United States. Overseas employees are going to have to, look to that sort of local law. But, it's going to revolve around common sense. Of course, an employer has a right to protect the workplace. They're going to want to make sure that it's safe. They have an obligation to make sure that it's safe. As long as it's not discriminatory when they collect information, as long as they're doing it on an even-handed way and not in a way that discriminates against folks, they should be able to collect basic health information, take temperatures, ask about whether you've been exposed or if you've been diagnosed, and treat that information in confidence, but then react in the workplace so that they prevent the transmission of the disease to other people, to your coworkers. If you have questions if you feel that they're asking too intrusive questions, talk to your employer. See if you can work that out. In the United States, talk to your union representative. If there's a workers' rights advocacy group in your community, talk to them. Or, of course, you can talk to a lawyer. But ultimately, these are voluntary relationships, and you can potentially, obviously, you can refuse to give the information, and then the employer will have to make a decision about whether or not to keep you on as an employee.
This is the debate of our era, right? How much of your privacy are you willing to give up for some sort of benefit, whether it's to be part of a social media community or whether it's to protect the greater health of the city that you live in? It's interesting stuff, Keir. Thank you very much.
Thank you, guys.